All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in Crown Atlantic versus AP Wireless Investments. Our case number CV140159. Each side is allocated 20 minutes per side. Appellant may reserve a portion of that time for rebuttal if you wish to do so. If you want to do that, please keep track of your own time at the clock on the podium. We will not be doing that. Out of respect for counsel, I would ask those in attendance to make sure that their cell phones are turned off or are muted so that counsel aren't interrupted. We have had an opportunity to review the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument to us today. Our proceedings are being recorded and will be posted to YouTube in due course. As you begin your argument, please state your name and the party that you represent. With that, Mr. Berry.
Good morning. May it please the court, my name is Kyle Berry. I represent the appellant plaintiff below, Crown Atlantic Company, and I'd like to reserve 5 minutes for rebuttal. I want to start today talking about the difference between a right of first refusal and a lease option to renew, because I think understanding how those two principles interrelate is essential to understanding Crown's interpretation of the lease that's at issue today. A lease option to renew entitles a tenant on a piece of property to continue an existing lease, and the tenant has complete control over when it's going to exercise that option. So typically those options are exercised during the term of the lease. The landlord knows if the lease is going to continue or not. The right of first refusal is very different because it only comes into play after a lease term is over. It gives a tenant one last opportunity to continue on the property by matching another offer to lease the property. And importantly, the tenant doesn't control when it can exercise that right of first refusal because it depends on a third-party offer coming in to trigger it. Now, so these aren't two mutually exclusive alternatives. They actually walk hand in hand. They entitle a tenant to extend a lease as far as it would like, and then at the very end, a chance again to match it and continue on.
But is that always the case, or doesn't it really turn on the terms of the specific contract that the parties have reached?
Well, it's always going to turn on the terms of the parties have reached, but I think understanding the context of how, again, this is a specific contract in a specific industry, and understanding how these things typically work is essential to the context, understanding how to read the terms of the contract.
Well, for example, a right of first refusal, I could envision a world where that would accrue before the expiration of the lease term. In other words, if you had a 120-day window to renew a 5 or 10-year commercial lease that was not exercised, but there was a right of first refusal in there, presumably the landlord, depending on the square footage you're talking, would want to be talking to Plan B to avoid any gaps in tenancy. Is that fair?
I think that's fair, but when you look at the realities of the situation, for example, let's take this case in particular. Our lease renewal option has a 90-day window that has to be exercised beforehand in this particular case. So if a tenant wanted to stay on the property, if we're accepting this interpretation that they're mutually exclusive, it's kind of one or the other, the right of first refusal would essentially be worthless, because if the tenant wanted to stay on the property, under virtually no circumstances would it blow through its right to renew in the hopes that perhaps there would be a right of first refusal. These two provisions are in for the tenant's benefit.
Wouldn't that turn, though, on market forces? I mean, if per square footage rental value remains the same, your hypo makes a lot of sense. But, over the course of this lease, there have been enormous changes in market value.
Well, there have been, and that's why the initial lease term option, or excuse me, lease renewal option, would have a rent adjustment for market rates. And so, going with market forces, I feel like Judge Easterbrook here. If we're talking about economics, a new offer that came in at the end of the lease term would be market rates. And so again, it would kind of be an apples to apples comparison, and you would always take the sure thing as a tenant, renew your lease at market rates, as opposed to blow through and kind of cross your fingers and hope that someone's going to offer a right for refusal.
Counsel, you mentioned that the right of first refusal has to have a trigger point, which I agree it does. I mean, a bona fide offer. But how do you take this one sentence that's at issue here? And can you explain what is the trigger point? What would have been theoretically, I mean, just theoretically, what would have been the trigger point?
Well, the trigger,
I mean, because there's no timeframes at all. I mean, it's just completely silent. So when would the seller be obligated to convey a bona fide offer?
well, our
Within a
interpretation-
reasonable time?
That's correct, Your Honor. Our interpretation would be that the right springs into being at the completion of the initial lease term. That's as early as possible.
Really? But to follow up on Judge Thelma's earlier question, what if the landlord knows a year in advance that tenant B has said, hey, I'll take that space. I'll take that space and I'll pay you $6 a foot. I mean, or, which is a different price. So, isn't there an obligation to pass that bona fide offer along?
There would be. I think that under this contract, the landlord would be prevented from accepting that offer until the right of first refusal sprang into being. So they'd offer it at the end of the lease term if there weren't any renewal options that had been exercised.
Does that make a lot of sense that you'd actually wait until nobody has a lease? I mean, the lease ends at midnight and then nobody has a lease.
Well, I mean, the landlord could certainly pass
Yeah.
that along, and it would probably be good practice to pass that along beforehand. But the right to go ahead and accept that and enter into that contract, I think it'd be fair to read under this contract that it wouldn't spring into life until there was no longer a lease on the property. In practice, parties will probably pick up the phone and call each other. But I think that and you'll notice that in the contract, nothing says that these two rights are mutually exclusive. Right? They don't say you can only exercise one if you don't exercise the other. And when you read the actual terminology again of the right of first refusal, Crown's reading of it is that there is a time when it springs into life, and that's at the completion of the initial lease term, which is what I said is as early as it possibly could. And it doesn't have a termination date. But that makes sense in this case because, again, this lease has options to renew, and so it's unclear when exactly Crown is going to be off the property. And also, it depends on a third-party offer. And so, to follow up on Judge Brown's comment, our interpretation would be that there would be a reasonable time period after the initial completion date that Crown would be able to exercise a right of first refusal. And our interpretation of that would be essentially while Crown is still on the property, would make sense that Crown would be offered a right of first refusal. If it's been off the property for 5 years, 10 years, it's probably not reasonable. But that's a question of fact, what a reasonable time period would be. And so when I answered Judge Thuma's question about kind of the realities of the situation and why a tenant would never really take that lease, would wait to exercise a right of first refusal when it had a lease option at its disposal. In Crown's view, that's just not reality, and that's just not reasonable. AP Wireless, I think, tries to justify that result by pointing to the word act. It's a small word and it's caused a lot of problems in this case. But any notion that the word act has been judicially defined and established in Arizona, Crown believes is just incorrect. The cases that are relied upon are the Ring case and the Blount case that interpret drunk driving statute and a workers' compensation fund statute, where the word at really isn't even an issue. And we're talking about an industry-specific lease between private parties, and so I don't think those cases are helpful. And as a matter of fact, we cited several cases to the court that reached the conclusion under leases and other contracts that the word at, when read in context, can mean after. The Texas company case out of Georgia back in the 40s says, and I'll read this quote because I think it's enlightening, says the word at is a term of considerable elasticity of meaning and is somewhat indefinite. As used to fix a time, it does not necessarily mean eo instanti or the identical time named or even a fixed definite moment. And the word at in this contract is equivalent to meaning to after, and that involves an option to terminate the lease. And so really to sum up, Crown's confidence interpretation of this lease is correct, but it's important to note that at this point in the proceedings, Crown doesn't need to be correct in its interpretation of the lease. All it needs to show is that its interpretation is reasonable. Because if it has a reasonable interpretation of the lease, the court can't make a decision as to which interpretation it's going to adopt as a matter of law. That's an issue of fact for the fact finder, and that's something that we learned from the Mayberry Ranch case. And so because Crown's interpretation is reasonable, On a motion for judgment on the pleadings, all allegations of the complaint have to be accepted as true. And if that's the case, then Crown states a claim for breach of contract.
So then your is that the basis for saying you didn't need to present any evidence in the Superior Court?
That's correct, that's correct. If our interpretation is reasonable, and then AP Wireless did what Crown alleges it did, then it's a breach of contract case is stated in the complaint, and a motion for judgment on the pleadings has to be denied. It doesn't mean that there couldn't be a motion for summary judgment down the line, after fact discovery has been accomplished. But at this stage in the proceedings, it's premature, and for that reason, Crown asks this court to vacate the judgment below and remand it for further proceedings. Thank you.
Thank you.
Thank you.
Mr. Morgan.
Good morning, may it please the court. Craig Morgan with Sharon 8 for Stinson Leonard Street on behalf of the appellate AP Wireless. Before I address some of the points raised by Mr. Berry, are there any specific questions I can answer from the panel in order to help facilitate a decision here?
Counsel, please proceed.
I heard Mr. Berry talking about reasonable time, reasonableness in time, and I want to make sure the court understands that what we're here for is and the issue before this court is, this is a situation, a case about contract interpretation. And this concept of reasonableness is the first time raised right here. If you look at their response below, this is what they said. It's on page 3. Plaintiff says at means after. AWPI says the right of first refusal expired if, on the day the original lease term expired, plaintiff did not exercise the right of first refusal. Now this is key. Plaintiff's interpretation is that if at any time after the original lease term expired, landlord found a new tenant, plaintiff would have a right of first refusal. Anytime. Not a reasonable time. Anytime. So the trial court below was tasked with determining whether that interpretation was reasonable. It was not. You can't have a right of first refusal on this contract expire anytime. And the reason you can't is you just look at the context of the contract. I mean, right above it, these parties knew how to say after, okay? Right above it, in the lease option provision, it says that you'll give at least 90 days prior to completion of the original stated lease term. Landlord and tenant agree that any additional lease term after the original stated lease term is subject to rent review and any lease changes. That's critical for 2 reasons. Number one, it shows they know how to temporally limit their clauses, okay? They know what prior means, they know what after means. It also defines the original stated lease term, but also the extended lease term. And I'll point out to the panel that that extended lease term was negotiated again and again and again, and not once did they revisit this concept of a right of first refusal. It wasn't edited or revised to provide that that right of first refusal continued, because it didn't. Now, the next question before this court is, did the court correctly determine in the context of the motion for judgment on the pleadings, okay, that appellant's interpretation of the clause was reasonable? Our position is that the trial court did. I've been thinking a lot about the standard for review, and I started looking at it again yesterday, and I know you have to accept the allegations in the pleadings as true as long as they're reasonable and not legal conclusions, that sort of thing. And I know you look at legal issues to know them. But this is a lot like a motion to dismiss, and this is where I think the court can really give us guidance, because as practitioners, you don't find a lot of judgment on the pleading cases. And in a motion to dismiss context, okay, it's reviewed for abuse of discretion. And I think you would review this the same way.
I'm sorry, motion to dismiss?
That's right. I was looking at it yesterday.
Actually, there's for a period of time, in 2007, there was a case, but there's a case, I think, from last year where the Supreme Court says, no, it's really de novo for a
It's
12B.
Coleman versus City of Mesa.
Okay,
Yeah, so,
that's
yeah,
fine.
yeah.
And the point is that in the context of the
Yeah.
motion for judgment on the pleadings, you just don't see that.
Yeah.
You know, so we really don't know what the standard is. But a nice expression of that standard would be great. So if you're looking at it from de novo, then this court's got to look down and say, okay, is this a reasonable interpretation? And what you've got before you are the pleadings and the contract. And if you look at that contract, I, for the life of me, can't say that it's reasonable to think that at any time after the original stated lease term, the right of first refusal can be exercised. It would make no sense. And it would essentially give them 50 years, 100 years, who knows. Whenever someone decided they wanted to give terms to a new tenant, they would have to look back and find this prior tenant, Mr. Berry's client, and under their theory, give them the right of first refusal. And that cannot be a reasonable interpretation of this contract. And that's what the Superior Court determined. And I believe the Superior Court was right. Now, if we talk about their cases, first off.
Counsel, let me, before you get there, you're right, motion for judgment on the pleadings at 12C is a fairly less common motion than a 12B or a 56. But you talk about the reasonableness. Is that an issue of law for the court? Or with State Farm versus Taylor, does that suggest, it's an issue of law for the court after discovery? Or help us out
Sure.
on that.
In State Farm, it is an issue of law for the court, Your Honor. And in State Farm versus Taylor, they held the court should only consider evidence if it's actually presented. And then if it's presented, you've got to make the next determination of reasonableness based on the evidence.
And that Taylor, I think, was a 56 or akin to a 56. It was a more robust record than that. How does that apply? What in the 12C context?
Well, in the 12C context, here's how I believe it would have applied, or could have applied below, because I'd have to guess. If you have evidence presented, and then you're stuck with a situation where the trial court can decide, hey, here's this evidence. Do I need to convert this to a Rule 56 motion? And then decide based on that or not. There was no evidence. That's our record. There was no evidence, you know this. But if they presented evidence, then the court would look at it and say, okay, but is this evidence even something I'll consider? Because first I've got to determine, is their interpretation of the contract reasonable? And that presumes, under in-ring marriage of Zale, which came out, it's a Supreme Court case, came after Taylor, some sort of ambiguity. And the problem here is it's not ambiguity. They're confusing ambiguity with really poor draftsmanship. This is just a really poorly drafted contract. It's not ambiguous. If it were ambiguous, we wouldn't be here. Okay? It's just a really, really bad contract. and there's nothing you can do about that but read it and go with it. And their interpretation of this really poorly drafted contract is unreasonable. And I don't think Taylor lends them any quarter. I don't think any of the cases about parole evidence lend them any quarter in that regard. And nor do these cases from other jurisdictions.
Let me, and I've interrupted you now twice as you were beginning to go to other jurisdictions. I want to hear about that. But what if instead, and I understand that's not what happened here, in response to the motion, appellant said, Judge effectively did a 56F, even though we're in Rule 12 land. We need to take some discovery. We need to get some information. Give us 90 days. And they go find an initial drafter who says, when we said at, we meant after. Does that theoretical or hypothetical change things?
If they can find a person to say, I drafted that and we meant after.
And again, that clearly is not the record before us.
Right.
No, but does that alter the analysis?
If I understood, I want to make sure I recap.
Sure.
So I
No,
understand,
that's fair.
because there's a lot to take in.
There is.
If they filed some sort of motion with the court and said, I want to take discovery, okay, and I want to have a certain amount of time, and then after they take that discovery, they find out from an original drafter at and after. Well, that assumes they can take the discovery. The problem you have there, number one, is, and I'll answer it as though it assumes, but I just want to point out, it assumes you can take the discovery because the court decided, you know what, that's a reasonable interpretation of the contract that they proffered. Assuming that happened, they took discovery, yeah, there would be an issue there, I think. I don't think I can say there wouldn't be, that someone who says, hey, I drafted it at and after. Of course, it's a Rule 56 motion issue.
Right, but we're not there yet.
We're not.
And so my follow-up question, then I'll let you get to other states' cases, but if that theoretical possibility exists in a Rule 12C context, doesn't that mean the court maybe should slow up on that record, which I understand is different than this?
On that record, yes. On our record, no. That wasn't a theoretical concept. No one said, hey, I think I can find someone, here's what I'm going to do. It's just not there. So the court was left with the pleadings and the contract. And you'll note in the record, the court did ask counsel, what else do you got? I'm paraphrasing, believe me, I'm paraphrasing. Okay, but he says, nothing. I don't know yet. I'm here arguing this. I don't know what I have. And it would have been maybe a different case if they would have come up with some sort of parole to show the court, assuming she could get past with that the reasonableness of the interpretation. That's why I believe we're right, is because it's just an unreasonable interpretation. It can't mean forever after. I don't want to giggle about it, but it just seems silly that you can always have the right of first refusal until someone gives you the right to, an opportunity to refuse it. It's just an unreasonable theory to assert based on this contract. Now, before I move on to briefly discuss the other cases, are there any other questions I can answer? Okay. I will note that in Arizona, I think there are some there's some guiding case law, which is, as a practitioner, refreshing and rare sometimes. Because to have this guiding case law on this issue is interesting. And we have at least two cases, Ring and Blount, that have interpreted somewhat similar statutory provisions with language somewhat similar to this contractual provision. And they made it very clear that afterwards is not an option when you're talking about that. And I think it's stronger in our case because unlike in Ring and Blount, where, and I think Appley conceded this in their papers, he says they're talking about timing. Well, that's our point. They are talking about timing, but so are we. And here you've actually got an honest-to-goodness temporal limitation at the expiration of the original stated lease term. That's a time period. That is May 31st, 2005, because the original stated lease term was June 1st, 1985. So if I did my math right, there's an end date there, okay? Whereas in Ring and Blount, they didn't even have an end date. They had an event. The event was either testing for the DUI or the onset of injury. And in those cases, that did not mean after. In here, we've got an actual date certain at cannot mean after. And that dovetails nicely into the cases they rely on below or on appeal, Texas company. I call it the crown jewel because when you read it at first blush, you go, gosh, they really are knocking this concept of that meaning after. But that case is very distinguishable. It involved a different contract clause that court actually considered ambiguous. Our case doesn't have an ambiguous clause. Our case doesn't have a reasonable interpretation of a clause. Our case has, their interpretation is reasonable. Our case has a very clear, unambiguous statement that you have to exercise the right of first refusal at the completion of the original stated lease term, which is a defined period of time. And even the dissent in Texas company would have gone wrong. I think it's important to remember that. That case is not dispositive of this case at all. The other two cases they cite, again, same thing. They recognize when you, under central guarantee versus Fourth and Central Trust, recognize that when you undertake to do a thing at a certain date, the word means on the date and not afterwards. That's at, I think, page 65 of that case. And I think that's key because that's what we've got here. We've got a date certain. It's just defining the original stated lease term. And the other thing to keep in mind with those cases is they all still hinged on this concept of reasonableness. And here what you have is an unreasonable interpretation. Again, they said in their papers, this is what we were dealing with below. Plaintiff's interpretation is that if at any time after the original lease term expired, landlord found a new tenant, plaintiff would have the right of first refusal. That's what the trial court was tasked with determining was reasonable. And it came to the conclusion it was not. And there's nothing wrong with that. Now, if there are no further questions, I have nothing else to say. I don't know if this is a record or not. I have my 7 minutes.
Thank you, counsel.
Thank you.
Mr. Barry, rebuttal.
Thank you. I said I'd take 5 minutes. I'm a man of my word, so I promise. I just want to address just a few quick points. First, we want to argue that the drafting of this contract leaves a little bit to be desired.
And I understand, I think we all do, that no counsel in the courtroom today had any involvement in the drafting, and I appreciate that.
But I think that's the exact reason we're here, is because the contract leaves a little bit to be desired, and so it can be read in multiple ways. And to talk about Taylor, I'm going to take a shot at how I think this review proceeds under a Rule 12C motion. And that's what Taylor tells us is that when a court is looking to see if a contract can be reasonably construed in multiple ways, Taylor tells a contract to look at proffered evidence, surrounding circumstances, look at that in making the determination if there's a reasonable interpretation that can go either way. And in this case, we've got a Rule 12C motion, which means that all the allegations of the complaint are accepted as true. And so that's the evidence that the court has, that's some of the evidence the court has to look at, including context. And once the court makes that determination, say, you know what, this contract can be read in one of two ways. I can't, as a matter of law, say there's only one way this contract can go. Then at that point, it gets kicked to the fact finder. And then after fact discovery, maybe it can be revisited as a matter of law down the road, but at a motion for judgment on the pleadings, it can't happen at that point. This talk about proffering evidence, again, we're on a Rule 12C motion. There isn't any evidence being proffered. The evidence is accepting Crown's allegations as true. And I'll just make a quick note that when that question was asked, counsel below, do you have any evidence? The court said, other than what your clients will say, do you have any evidence? And counsel said, well, no, I'm not aware of any. Certainly what Crown's clients have to say about what they understand the contract to mean, how the parties had acted under the contract, that would certainly be evidence of contract interpretation, I believe.
Well, that would be evidence of something, I agree. But you mentioned, if the court determines a contract reasonably, and you may not have used this exact syntax, can be read one of two ways, then you're in fact land. But didn't the court here say the contract can be reasonably read only in one way?
The court did say that, and we think that's an incorrect legal conclusion. That's certainly a matter of law that we believe the court erred, that the contract can be read one of two ways. And I understand, we can certainly concede, although Crown believes that its interpretation is the correct one, that you could read this contract the way AP Wireless is reading. We think it's highly unlikely AP Wireless is reading this contract to say that there's a one moment in time that this right of first refusal can be exercised. It depends on the third party offer triggering it, obviously, but there's this one moment in time at the end of a completion date, at the end of a term, when a contract includes renewal terms that you can exercise that. We think that's a highly unlikely interpretation, but we'll submit for the purpose of this appeal that it can be read both ways. And the fact of the matter that there are competing jurisdictions out there that say that act can mean after, that in certain circumstances and context that these words can mean after a reasonable time, that alone should show us in the court that there are reasonable interpretations of this contract. And so, to steal Judge Thune's phrase, we're in fact. And the last point that I want to make is there's talk about this reasonableness that came up for the first time on appeal. We disagree with that. If you look at the entirety of Crown's response to the motion below, and I'll read a couple quotes. This is on page 2 of our response. It says, plaintiff claims that at the end of those options, plaintiff has a right of first refusal to accept any lease the landlord enters into. That's Crown's interpretation of what a reasonable period of time would be. It would be at the end of those options. It's also on page 4 of our response where we said the right of first refusal would not have brought any benefit to plaintiff unless it meant that once the renewal periods had expired, it also had a right to refuse. And again, that's Crown's interpretation of what would be reasonable. And so again, for those reasons, we'd ask the court vacate the judgment below. If there are any other questions, that's all I have.
Thank you, counsel.
Thank you.
Counsel, we appreciate your briefs. We appreciate your argument. We will take the matter under advisement and we'll issue a ruling in due course. Thank you both. We stand adjourned.
Thank you.